This is property, part one, ownership. There is present and future possessory interests. These are subject to the rights of others. There are non-possessory interests, and these are subject to specific restrictions as to the use of land. That makes sense. Non-possessory interest must be restricted as to use. Looking at present estates, very generally, a freehold is an immobile piece of property, an immobile property interest, which is for an indeterminate duration, and this is opposed to a fixed term leasehold. You have a fee simple absolute, and that is absolute ownership of an indefinite duration. It's freely alienable, it's easily bought or sold, and it has no accompanying future interest. So this is a non-defeasible fee. A fee simple absolute is just absolute ownership. To create a fee simple in a conveyance, this generally requires the words, quote, and heirs, such as to Brent and heirs, end quote, but is considered, the conveyance will be considered a fee simple without the and heirs. Looking at a defeasible fee, and defeasible fees are fees that are open to revision, valid objection, forfeiture, and or annulment. So these are fees that you can lose. A fee simple absolute is absolute ownership. You can't lose it. A defeasible fee is a fee that you can lose. So a defeasible fee is ownership of a potentially infinite duration, but may be terminated by the occurrence of an event or condition. You have a number of fee simples. You have fee simple absolute, which we discussed. But looking at defeasible fees, you have a fee simple determinable, fee simple subject to condition subsequent, fee simple subject to executory interest, a life estate. Looking at fee simple determinable is a fee simple limited by specific durational language, such as so long as, while, during, until. It's freely alienable, divisible, and descendible, but terminates automatically upon the happening of the condition in the conveyance, and full ownership reverts to the grantor. This is known as the possibility of reverter. If the condition happens, ownership reverts to the grantor. That is the possibility of reverter. This is the grantor's retained future interest, such as the fee reverting to the grantor upon occurrence of the condition. I have that in there again. This future interest is freely alienable by the grantor during life and death. So this possibility of reverter is alienable by the grantor during their life and during death. Next, you have a fee simple subject to condition subsequent. This is a fee simple that is limited in duration by specific conditional language, such as provided that, on the condition that, but if. Again, so condition subsequent is limited by conditional language. Determinable is limited by durational language. Two differences, nuances in that. Fee simple subject to condition subsequent is freely alienable, divisible, and descendible. Termination of the fee simple subject to condition subsequent is not automatic. It will only terminate if the grantor affirmatively demonstrates an intent to terminate upon occurrence of the condition. On the exam, where there is ambiguous language, courts prefer this status. Now, this right to terminate by the grantor is known as the right of reentry. Condition subsequent, this is right of reentry. This is known as the right of reentry. That's the right to terminate is known as the right of reentry. That right of reentry must be explicitly retained in the conveyance. Majority of states consider the right of reentry divisible and descendible, but cannot be transferred, cannot be devised or descended during the grantor's lifetime. Again, that is different from the fee simple determinable, where the possibility of reverter is freely alienable by the grantor during life and death, subject to condition subsequent. The right of reentry is not during life, but it is at death. Next, you have fee simple subject to executory interest. This is a fee simple that is limited in duration. There's conditional, durational language. It's kind of a mix of the two above. This terminates automatically upon the occurrence of the condition, and title at that termination passes to a third party other than the grantor. Next, you have a life estate. A life estate is a present possessory estate. It's limited in duration by a life. It's created by a conveyance such as to a for life, such as when my grandfather died, he gave my grandmother the house for her life. So when she dies, at the end of her life, the title reverts either to my grandfather, who, if he was alive, but he's dead, or the Remainderman, which would be his children. So they're the Remainderman. This is known as a reversion. Again, so life estate, present possessory estate, limited in duration by a life, created by the conveyance to a for life. At the end of the measuring life, title reverts to the grantor or Remainderman. This is known as a reversion. This is not subject to the rule against perpetuities because it does have an exact measuring life. Measuring life is that of the grantee. It's fully transferable, generally not divisible nor descendible. Measuring life may also be that of a third party. Rights and obligations in a life estate, rights to possession, rents and profits, lease, sell, mortgage a property. That's the right of alienation. However, obligations include paying taxes and rent if required. There's no obligation to insure for the benefit of the Remainderman. And the life estate, the holder of the life estate is not responsible for damage caused by third-party tortfeasors. There is a duty not to commit waste. Looking at waste, the grantor or Remainderman may enter to inspect for waste. There is affirmative waste. This is overt conduct that causes a decrease in the value of the property. There's permissive waste, which is neglect or failure to keep the property up. There's ameliorative waste, and the majority of courts hold that life tenants can alter structures when necessary to make reasonable use of the property, and that completes part 1 of property.